Welcome to BusinessTraining.com. Today's video module is focused on the Equal Pay Act as enacted by Congress in 1963. This is our agenda for the video topic today. Please take a moment to review the outline. The Equal Pay Act was enacted by Congress in 1963 as an amendment to the Fair Labor Standards Act. The EPA applies to almost all employers and employees, and the Act prohibits pay differentials based on gender for employees working in substantially equal jobs, requiring equal skill, effort, and responsibility in similar working conditions. The EPA does not have exemptions for executive, administrative, professional, or outside sales as there are under the Fair Labor Standards Act. The Equal Pay Act does permit differences in wages if it is based on seniority, merit, quantity, or quality of production, or a differential that is based on a factor other than sex. If an employer violates the Equal Pay Act, they are liable for damages equal to those under Title VII, which include lost wages, benefits, reinstatement, civil fines, and attorney's fees. Liabilities can also include compensatory damages for wages or emotional distress, but these liabilities are capped and the amount an employer is liable to pay will vary depending on the size of the employer. However, if an employer is found to have acted willfully in the pay discrimination, they may be held liable for liquidated damages for double fines. If an employee wants to prove that an employer is violating the Equal Pay Act, they must first show that there is differing wages paid to employees of the opposite sex, even though both parties perform substantially equal work that requires equal skill, effort, and responsibility under similar working conditions. The emphasis on work is that cases on pay discrimination are reviewed not on title or duty description, but on the actual work and job done. All these criteria must be met to be found an Equal Pay Act violation. If a male supervisor of sheet metal production is paid higher than a female supervisor of sheet metal production working in a different factory, and the male works in an area of high probability of tornadoes and floods, it is likely that the male supervisor will be paid more as he works in more dangerous environment and working condition. Employers, however, can try to avoid liability by proving that higher wages are not based on gender but instead on seniority, merit, a system that measures earnings based on quality or quantity of production, or some other factor besides gender. The Equal Pay Act requires workers to be paid the same rate for the same job, but they are also entitled to the same benefits. The benefits include everything from health and life insurance, retirement plans, and use of company equipment, bonuses, vacation time, profit sharing, hotel accommodations, and anything else that could be considered compensatory benefits or pay. The Equal Pay Act states that the time limit for filing an EPA charge is within 2 years of the alleged unlawful compensation practice. If the violation is a willful violation by the employer, however, the victim has 3 years to file a charge. Employers may not reduce the wages of the higher paid individual so that both parties have equal pay and be in compliance. They must increase the lower wage to match the higher paid wage. The Lilly Ledbetter Fair Pay Act was enacted by Congress in 2009 and amends the Title VII of the Civil Rights Act of 1964. It changes the 180 statute of limitations for filing an equal pay discrimination lawsuit, so that limitations reset every time an employee becomes subject to a discriminatory pay decision or practice or every additional application of that decision or practice. In other words, each time compensation is paid. The statute of limitations used to state that the limit for filing pay discrimination lawsuit was 180 days from the date of the agreed-upon pay decision. This law was enacted as a direct response to Ledbetter v. Goodyear Tire and Rubber Company, where the Supreme Court ruled that Lilly Ledbetter's complaint was time-barred because the discriminatory decision related to her pay had been more than 180 days prior to the date she had filed the charge, even though she had only discovered her pay discrimination near the end of her career. The Lilly Ledbetter Fair Pay Act allows an employee to recover back pay for up to 2 years preceding the filing of a discrimination claim. The Fair Pay Act changes apply also to claims that are filed under the Americans with Disabilities Act and the Rehabilitation Act. The Pregnancy Discrimination Act was enacted in 1978 to amend Title VII of the Civil Rights Act of 1964. The PDA prohibits discrimination on the basis of pregnancy, childbirth, or other pregnancy-related medical conditions. It applies to all companies of 15 employees or more and is enforced by the Equal Employment Opportunity Commission. Under the Pregnancy Discrimination Act, employers have a lot of restrictions and requirements to ensure full compliance with the regulation. Employers cannot refuse to hire or fire an employee or job candidate on the basis of pregnancy or a related condition, so long as the employee or candidate can reasonably accomplish the job tasks, duties, and responsibilities. The employer cannot require that the employee submit to special procedures in order to determine the pregnant employee's ability to perform job duties, unless it is a requirement for all employees to do so, such as a physical abilities test, for example. Employers must treat pregnant employees who cannot perform job duties due to the pregnancy or related condition in the same way as all temporarily disabled employees. The employer may also not require the employee to stay on leave until the baby's birth if she had taken leave for a pregnancy-related condition. The employer-provided health insurance plan must treat pregnancy and pregnancy-related conditions similar to other medical conditions. In other words, the plan must cover expenses for pregnancy-related conditions on the same basis as they cover costs for other medical conditions, and the pregnancy-related expenses must be reimbursed in the same manner as those incurred for other conditions. The employer also cannot require the employee to pay a larger health insurance deductible than other employees pay. As stated, a pregnant employee cannot be forced to take leave as long as they perform their jobs. If they cannot, the employee must be treated in the same way as temporarily disabled employees by being provided modified tasks, alternative assignments, or offering disability leave or leave without pay to reasonably accommodate the pregnancy-related condition. Employers are required to hold jobs open for pregnant employees for the same length of time as is held for employees on sick or disability leave. Any fringe benefits that are offered to workers on leave must also be offered to maternity and pregnancy-related leave, and the employee must also continue to accrue or credit seniority, vacation days, pay raises, and other benefits that are offered to temporarily disabled employees. Pregnant employees can also have additional rights under the Family and Medical Leave Act. Employers need to be conscious that policies that deny pregnancy leave during the first year of employment but provides leave for other conditions would be discriminatory, and even a neutral policy prohibiting an employee from taking sick leave or short-term disability leave during the first year could be considered disparate impact discrimination against women. If you would like more information on any of these topics, please go to the U.S. Equal Employment Opportunity Commission website at the following link. Thank you once again for your time and attention, and this is BusinessTraining.com, where you can earn a master's level qualification to make more money.